By asking you a question?
Who comes up and asks? That's crazy.
And it scared you?
Doing your job.
Really going out off the
Yeah, this is how you guys.
This is bad.
On August 7, 2020, deputies Dalton Martin and Jordan Horn from the McDowell County Sheriff's Office in West Virginia approached Donnie Harrison, 66, and his wife Ventress, 63, while they were sitting on the porch of their rental home owned by former military police officer Jason Tartt. The deputies questioned the couple about 4 suspected marijuana plants found on nearby property owned by a third party, to which the Hairstons denied any involvement. Persisting with their inquiries, the deputies circled the property and peered through windows before calling Mr. Tartt over from his nearby residence. This entire interaction was recorded on Deputy Martin's body camera. Ever wondered what unfolds during tense police interactions? Let's explore now. You're watching Cops and Consequences. Subscribe now to join our community.
Just because in the season that we're living in, I think it's important that I have your names.
What do you mean, ma'am?
A lot of crazy stuff going on. And so having your name makes me feel more secure. As I said, we came here June 28th. You know, we're actually new here.
Okay.
And for the police officers in this area to come up and say, "Are you growing marijuana?" That is preposterous to me.
Is just a question, ma'am.
Yeah, well, I get that. And so then my only question to you is your names, just so it's okay in my own heart and mind. And when I say the season we're living in, you know the season we're living in.
Y'all concerned about something over here at this house?
This house?
No, that house.
Yes.
What's the problem?
Who lives there?
Mr. Ferguson. He's probably there now. He's 79.
Okay. All right. What's your name,
You
sir?
can knock
Jason
on the door.
Tartt.
Jason Tartt.
Tartt.
And what do you mean by the season we're living in, ma'am?
Sir.
What do you need? You got any questions for me?
No, I'll collect some information from you in a minute. Your name and date of birth and such.
What do you need my information for?
You own these 2 homes, correct?
What
Okay,
do these 2 homes got to do with that?
These
church?
2 homes is near that marijuana grow, so I'd just like to have your name.
You know how many people go through here?
I understand.
That's not going to do you one bit of good.
Okay. Well, sir, I'm going to need your name and date of birth, and I have that.
I don't feel comfortable giving you my name and date of birth.
Okay, well, this is a criminal investigation. You own these 2 homes, so by law, you do have to give me your name and date of birth, sir.
If he gives you a reason, yes, you do.
Reason for what?
Because of the marijuana grow.
It's not on my property.
Okay, well, again, I have reason to believe that these 2 homes here that you own is related to that marijuana grow, so you have to give me your name and date of birth by law.
The deputies informed Mr. Tartt that he was legally required to provide his name and date of birth. In West Virginia, there isn't a specific statute that allows officers to arrest individuals solely for failing to identify themselves. Instead, officers typically rely on the state's obstruction laws to make such arrests when individuals refuse to provide identification under certain circumstances. In the 2003 case of State versus Serinsky, the West Virginia Supreme Court of Appeals ruled that simply refusing to identify oneself does not automatically constitute obstruction of a law enforcement officer performing their duties. However, the court clarified that obstruction charges could be valid if the refusal occurs after the officer has explicitly stated the reason for requesting the identification, or if it's mandated by specific statutes. Although the deputies provided a reason for asking Mr. Tartt's name, citing the proximity of his property to the alleged marijuana plants, the Fourth Circuit Court of Appeals later determined in the 2021 case of Wingate v. Fulford that enforcing stop and identify laws without a valid investigatory stop based on reasonable suspicion is unconstitutional. Given this precedent, it is probable that a court would rule that the deputies lack the constitutional grounds to arrest Mr. Tartt for not identifying himself in this scenario. Additionally, since Mr. Tartt did provide his name initially and there was no requirement to disclose his date of birth, his actions likely wouldn't meet the threshold for obstruction.
Go get a pen and piece of paper.
Reason to believe what? Why? Because these houses are here. Do you understand that there are a lot of traffic going through here?
Since we've lived here, people come up here and they park there and we don't know where the hell they go, and then they come back out.
I don't have a problem giving you my information. I'm just
Okay, well,
trying
that's
to
all I
understand
need. It doesn't have to be an argument. I mean, just give me your name and date of birth, dude. It's easy.
It's not easy. My property has nothing to do with what you found.
Okay. Well, we're just making sure of that.
Well, you scared me. I mean,
Scared
who
you?
says that?
By asking you a question?
Who comes up and asks? That's crazy.
And it scared you?
I'm trying to understand what
It scared you by me asking you a question.
Growing marijuana?
And that's a question. To say somebody scared you because they asked you a question is ridiculous.
That's preposterous.
Go ahead and give me your name, sir.
Wait.
First name.
It's ridiculous to you, sir.
Yes, ma'am.
But it's not ridiculous.
Your first name.
I'm not giving you my information.
Sir, if you refuse to give me your information, I'm going to arrest you.
That's fine. My property has nothing to do with any marijuana whatsoever. You're going to arrest me if I don't give you my name and date of birth.
It's obstructing an officer.
How?
Because you're hindering me from doing my job. You're hindering me
How
from...
am I hindering you from doing your
Sir.
job if it's not on my property?
Last chance to give me your name and date of birth, sir.
How am I hindering you?
Sir, last chance to give me your name and date of birth.
How am I hindering you?
Place your hands behind your back. Place your hands behind your back. Are you going to give me your name and date of birth?
Take me to jail. You're right. I'm hindering you from doing your job. Please.
I'll see if I can find you my name first.
No, I'm hindering you from doing your job.
Really going out off the
Yeah, this is how you guys.
This is bad.
This is,
112 control.
this is how you operate.
This is a wrap.
I'm hindering you from doing your
That's why
job.
I needed their.
Y'all need to go inside. Again, you two go inside. Go inside.
I'm afraid.
Go
now,
inside.
to tell you the truth.
Go inside.
On my own porch?
No, go inside as of right now.
Tell me why.
Go inside.
What are you doing,
Step off the
man?
porch. Step off the porch.
I'll step off.
Go inside.
What are you doing? This is unnecessary for
Sir,
you to be
go
doing
inside.
This. He's standing on his own porch.
Go inside.
Don't come in my house.
Go inside. Step back. Go inside.
Look,
Thank you.
that's completely uncalled for.
During the encounter, Mr. Harrison began filming the interaction between the deputies and Mr. Tartt. In response, Deputy Martin pushed the Hairstons into their home, effectively stopping Mr. Harrison from continuing to record the situation. While many federal circuits recognize that the First Amendment protects the right to film police officers performing their duties, the Fourth Circuit, which covers West Virginia, has yet to make a definitive ruling on this matter. In a 2009 case, the Fourth Circuit stated that the right to record police activities on public property was not clearly established within the circuit. Subsequent cases have left the legal status of this right in the Fourth Circuit ambiguous. In 2021, in the case of Hulbert versus Pope, a U.S. District Court ruled that an officer could be held accountable for arresting individuals who were recording police activity on a public sidewalk, denying the officer qualified immunity. This case is still pending in the Fourth Circuit Court of Appeals, and its outcome is expected to clarify whether recording police officers is protected under the First Amendment within this jurisdiction. Until a clear decision is made, it remains uncertain how courts would view Deputy Martin's actions in stopping Mr. Harrison from filming, and whether such actions constituted a violation of Mr. Harrison's constitutional rights at the time of the incident.
Come on.
Look,
Walk.
man, don't listen.
Sir,
You don't have to listen,
You're
man.
being recorded.
Listen. This
Just
is
walk.
listen.
Walk.
Listen. I can walk. I can walk
Okay,
without
well,
you
walk.
putting your damn hands on
Walk
me. You
to the
understand?
vehicle.
I have not broken the law.
Walk to the
At
vehicle.
all.
Well, walk to the vehicle,
Don't
sir.
put
You're
your
being
damn
recorded.
hands on me. I give
Sir.
you no reason to touch me.
I'm going to arrest you then. Place your hands behind your back.
Uncalled for.
Place your hands behind your back.
Put your hands behind
Place your hands behind your back.
Listen.
Look, just relax, okay?
Listen. You
Relax.
Place your hands behind
Okay.
your back. Please place your hands behind your back.
My hand is behind my.
Place your
It
hands
only
behind-
takes one of you.
Place your hands-
Look, let him do it. All right. Take your hands off me.
That's fine. Okay.
Let him do it.
Let's walk this way.
Deputy Martin began the arrest of Mr. Tartt on the porch by instructing him to place his hands behind his back and step down. Deputy Horn then handcuffed and took Mr. Tartt into custody in the driveway area in front of the home. The Supreme Court has established that the area immediately surrounding a home, known as the curtilage, is considered part of the home for Fourth Amendment protections. In the 2021 Longa versus California case, the court ruled that without urgent circumstances, pursuing a fleeing misdemeanor suspect does not permit an officer to enter the home or its curtilage without a warrant. Additionally, in 2018's Collins versus Virginia, the court determined that if a law enforcement officer physically enters the curtilage to gather evidence, it constitutes a search under the Fourth Amendment and is generally unreasonable without a warrant. However, earlier cases such as United States versus Watson, 1976, and United States versus Santana, 1976, have established that the front yard or porch can be considered a public area for Fourth Amendment purposes. In Santana, the court concluded that what is exposed to the public is not protected by the Fourth Amendment, allowing warrantless arrests in such areas based on probable cause. Given these precedents, there is a possibility that a court might rule that Mr. Tartt's arrest on the porch or yard did not violate the Fourth Amendment. However, since more recent cases like Longa and Collins involve different circumstances, a court might also decide that Mr. Tartt's situation is distinct and that the arrest location did not infringe upon his constitutional rights.
He owns two properties right here on this Baptist Drive road. We located a marijuana grow, probably not 100 foot, 50 foot from this last property of his, and he just won't give us his name, date of birth.
10-4 is male, white male, black male.
Black male.
After arresting Mr. Tartt, Deputy Martin collected the alleged marijuana plants and placed them in the vehicle's trunk, likely to use them as evidence. Mr. Tartt faced charges for obstructing a law enforcement officer, but the case was dismissed on October 28, 2020, due to Deputy Martin's failure to appear in court. On August 9, 2022, Mr. Tartt and the Harrisons filed a federal lawsuit against the deputies, and as of now, the case remains ongoing. Throughout the encounter, Deputy Martin and Deputy Horn maintained a forceful and aggressive demeanor, arresting Mr. Tartt after he had already provided his name, and restricting Mr. Harrison from filming by pushing the family into their home without clear justification. While the officers might receive qualified immunity for some of their actions, this does not necessarily reflect professional conduct or the absence of potential constitutional rights violations affecting Mr. Tartt and the Hairstons. Conversely, Mr. Tartt and the Hairstons remained calm and respectful during the interaction, sought to uphold their constitutional rights, and pursued legal action following the incident. Their decision to file a lawsuit highlights their determination to address the infringement of their rights, despite the complexities surrounding qualified immunity. Their actions serve as a testament to standing up for constitutional protections, and their case will be closely watched as it progresses through the legal system. If you have any interactions or legal topics you'd like to see covered, leave a comment below. Thank you for watching Cops and Consequences. Stay informed and stay engaged.